All right, and welcome to this episode of Crime Inc. Every episode will take a look at an aspect of the criminal justice system through the eyes of our guest. My name is Alexander Benikov, and I'll be your host. I'm a defense lawyer, author, adjunct law professor, and pretty much as long as I can remember, I've been interested in the criminal justice system, which is probably why I became a defense lawyer. Our guest today is an old friend of mine. I've known him for, how long has it been? 6, 7 years, something like that? 8 years?
Something like that.
Something like that. Is former defense attorney Kirk Nurmi. Mr. Nurmi is one of the best defense lawyers I know, and if I ever got into major trouble, his skills would be somebody that I would want. He's an excellent lawyer, and we'll get more into that. Thank you for being with us. Before we begin, where can people find you before I forget? Twitter,
first,
website?
Thank you for the kind introduction, and you can find me and what I'm up to right now on NurmiUnchained.com.
Very cool. And you're on Twitter also?
I am. It's at Nurmi Unchained on Twitter.
Very cool. So I wanted to have you on to talk about capital cases. It's a complicated area of law. I think it's often misunderstood. And first of all, before you got into capital cases, how did you get into criminal defense?
Well, when I started law school, I had an interest in doing criminal defense work, and a lot of people going into law school would tell me, oh, you're going to change your mind, and I never did. I graduated in 2000 and went to work that fall with the Public Defender's Office in Maricopa County, and then I just stayed with it for there. So I was in doing major felonies within a few months, and after about probably 6 to 7 years, I started doing capital defense work.
And what kind of cases did you do before that? Just all kinds of felonies?
All kinds of felonies, in general for the first few years. And then for probably about a couple years, I did a lot of major sex crimes as well.
Okay. Were you always interested in criminal defense, or is it something you kind of found in law school, or do you remember when it was something that became interesting to you?
Well, like I say, I went to law school with the idea that criminal defense was going to be the field that I wanted to pursue. So that was really my motivation. I just never could find any motivation for any other type of law, business law, things like that. The Constitution and those Bill of Rights that we all enjoy was something that was very important to me. So actualizing that in terms of being a criminal defense lawyer was just the passion I went to law school with, and it's the passion I left law school with.
Do you know where that came from? Any theories? I'm always curious because I was kind of the same way, but
I don't really know. I think there's something that's just a part of us that develops over time. And even though I went to law school at a later age, people ask me that occasionally, and I wish I could pinpoint one thing for myself and answer their question, but I just can't.
Yeah, I was kind of the same way. I could never really see myself doing real estate law or pretty much any kind of civil stuff. It always seemed like it'd be a tough road, but I guess to each person their own, because I'm sure some people could never imagine doing defense stuff. So
yeah, that is true.
Yeah. When you were at the PDs, were you wanting to get into capital work, or how did that happen?
It was never really the end goal. It was just after a certain amount of years, I began to think about doing different things in my career. And, I had, on a personal level, an objection to the death penalty. And so it just seemed like when the opportunity arose, that maybe, going into that line of defense would be something that I should think about. And I decided to do that in about 2007-ish. That's when I decided to begin my work in capital defense.
And from my understanding, most PD offices, or at least yours, it was kind of a seniority system. So obviously they don't give the capital cases to the person right out of law school. So it's kind of like a number of years or seniority or experience, or how does that work?
Well, yeah, the Arizona rules actually require that somebody have 5 years experience practicing criminal defense before they can even be on a capital case. We've heard horror stories out of states like Texas when they were executing every other person, that they were being appointed by real estate lawyers and people that did not have the qualifications. And what Arizona did years ago is adopt the ABA guidelines and say, okay, you have to have 2 attorneys. One has to have experience in capital defense, and one has to have at least 5 years in criminal defense. So there's always a person that is experienced, has gone through a capital trial before on a defense team that is typically the lead of that defense team. And there is always someone with 5 years. And there's a certain amount of felony trials. I can't remember off the top of my head, but you have to have a certain amount of felony trials and that sort of thing. So, like you said in your question, you don't just get to walk out of law school and defend a capital case in Arizona, which is fortunate for the defendants in Arizona.
Yeah, because you figured, I almost said literally, misused literally on my own podcast, but you figured to have people's lives in your hands. And it seems like pretty common sense idea that you would want, somebody doing capital cases with a, decent amount of criminal experience. It's amazing that not all states. A bit off topic, any idea what's going on with some of those other states? Have they kind of figured out that it's a good idea to have, or has the Supreme Court weighed in on it, if you know?
Well, I don't know off the top of my head, but I know that some of what the states was doing is what prompted the ABA guidelines to be, instituted or created, I should say, and then ultimately instituted in some states. The other thing I would say is that the ratio is probably, or the percentage is probably as high as 50% of cases getting overturned, death sentences, not the entire case necessarily, but death sentences getting overturned because a person did not have competent counsel. And I think perhaps as our discussion goes on, we'll talk about the enormous cost of the death penalty. But I think the Supreme Court, while they didn't directly weigh in and say, to my knowledge anyway, to say these are the standards that somebody must have, they will judge the competence of the representation regardless of that person's experience. I mean, I could have, I had several years experience, but if there's a case that there was a death sentence imposed, that doesn't matter. They're going to look at everything I did or didn't do in analyzing whether a person got full and complete defense, both at the guilt phase and the sentencing phase. So it's serious business, and the Supreme Court has taken seriously the standards imposed on those lawyers that are in place in those cases.
That makes sense. So you were at the PDs, you said, about 7 or 8 years before you got your first capital case?
Somewhere in that range, yeah. I moved to the capital unit, and when we talk about me getting my first capital case, remember there's a team of attorneys. So my first case, I was what they would call co-counsel or second chair on the case, because in order to be lead counsel, I have to have gone through at least one capital trial as a second chair.
And approximately how many trials had you done by then, approximately, just to give an idea?
Approximately a bunch.
a large amount, more
a large amount.
Yeah, more than a few.
More than a few, and probably dozens. It's really hard to say. The life of a public defender involves a lot of trials that are somewhat either short or the lengthy variety. So
at least
I had several.
At least I won't do that thing that my first year law students do, where they ask me how many cases have I won, because at least I know better than to ask that. Yeah, I'm always amazed. Be like, Professor, what percentage of your cases have you won? I was like, I wouldn't be able to sleep at night if I knew the percentage. That's a different conversation.
Yes, indeed.
Yeah. So, do you remember when you first got the case, your first one?
Yeah, I do. I mean, I like I say, I do remember walking into what I had done. Kind of somebody had left the defense team, and I walked into a case that was, already in progress, shall we say. It was something that had been, capital cases take a long time to process, and the case was something that had been in the system, so to speak, for well over a year, and was probably 6 to 8 months away from starting trial when I became a part of the case.
What kind of case do you remember?
It was all capital cases, in case anyone doesn't realize, has to be first-degree murder. So it was a first-degree murder case. There were 2 victims, so it was 2 counts of first-degree murder, and I believe there were 2 counts of kidnapping, probably 2 counts of aggravated assault, dangerous because of the pointing of the weapon at the individuals, and there may have been some other charges as well, but those were the 6 biggies, as it were.
And for those people that don't know, can you give a brief summary of first degree versus second degree, the difference in Arizona?
Well, it's not as black and white as one might think, because first degree murder is most prominently described as meant to do it, planned on it, acted on that plan, and knowing that the plan would result in the death of another individual. Manslaughter, just to kind of give us the parameters, manslaughter is a heat of passion type of thing. Some sudden enragement, that sort of thing, maybe no plan. Sudden you get angry and commit a murder. Second degree is kind of in the middle of those two. It doesn't arrive with the same amount of premeditation. It's not a well thought out plan, but there is still time for reflection and before the act of killing is committed, knowing full well that the result will be death. And the reason I say it's a bit of a gray area is because ultimately all acts along that scale require a level of premeditation. The really difference between first and second degree perhaps can be best described as the extent of that premeditation.
Well, that makes sense. So you mentioned that in Arizona there'll be at least 2 defense lawyers on a case, or always 2, or how does that work?
On a capital case, there has to be 2.
Okay.
That is what the ABA guidelines recommended, and that is what Arizona instituted. And the reason for that is, and we can get into it more in depth later, but the reason for that is the Supreme Court essentially requires that when you have a capital case, you have to investigate someone's life from conception, literally from conception to the day that they are being sentenced, because the Supreme Court requires that individualized sentencing practices be utilized. So going back to kind of what you talked about with other states tried to institute rules that said, if you kill a police officer, you get the death penalty. Well, the Supreme Court said, no, you have to give individualized consideration under the 8th Amendment to each and every person that goes before the court. So the jury is required to consider that before rendering sentence, which means that the defense attorneys are required to investigate that.
That makes sense. So as far as, because one of the things that's always been interesting to me as far as like when you have a team of lawyers, defense lawyers are kind of, we're social animals, but we're also individual animals, right? So we're used to doing trials on our own. We're used to kind of, making our own roadmap. So how was that initially for you? Because you mentioned being part of a team as opposed to, what you were used to the past, 7 or 8 years, where it's just you.
Well, that's a great question because it really is a different dynamic, and you're right. Defense attorneys are really used to steering their own ship, and that always doesn't become the case unless your lead counsel. But it strictly, it becomes the norm, and I think when you start really understanding what you're doing and the enormity of it all, those kind of differences those kind of arguments become less prevalent because there is that one goal in mind, and presumably both attorneys are there because they are against the death penalty and want to save the client's life.
Yeah. Is it because you've second chaired, you've first chaired cases? How does it normally work, or how's it supposed to work? How does it actually work as far as does the first chair make more of the big decisions, or if that makes sense?
Yeah, well, yeah, the ultimate responsibility for the representation goes upon the lead counsel, and that's why those distinctions are made. Somebody has to make the call. For example, if one attorney on the team thinks a certain motion should be filed and the other one doesn't, or thinks that this issue should be raised and the other one doesn't, ultimately it's on the lead counsel. Lead counsel bears all responsibility for directing, not just the co-counsel. One of the things we haven't gotten into is the the fact that this defense team also includes investigators and mitigation specialists. So ultimately the lead counsel is the director of that ship, and co-counsel kind of serves as first, so second in command, I guess you will.
Well, while we're here, can you explain what those titles are as part of the other members of the team?
Sure. Going back to, using the mitigation specialist, a death penalty case has really two prominent phases. And those phases are the guilt or innocence phase, which is what people associate with as the quote-unquote traditional trial, and a sentencing phase. So the same jury in a death penalty case, if they find someone guilty of first-degree murder, then is tasked with deciding whether that person is to be sentenced to life or whether that person is to be sentenced to death. And the state, in order to get, as a precursor before the case even goes as a death penalty case, has to prove certain aggravating factors to the judge that are codified in the law to prove that those factors exist in order to charge the death penalty. The mitigation specialist is the person that works on what we might call mitigating evidence, reasons not to kill a particular defendant. So they look more closely at some of the things that I talked about earlier, the reasons not to kill, like regarding the investigating the life of a defendant from conception to day of sentencing. So a mitigation specialist will go look at their school records, might talk to teachers, see if there's any signs of mental illness, might talk to relatives to see if there's any signs of fetal alcohol, if a parent is unwilling or unable to divulge that information. They will take a look at all those, what we call mitigating factors under the law to decide, and the lead counsel decides which, if any of those, are presented to the jury. The investigator is probably a little easier for most people to understand, that they investigate the case anew, which is another task that the defense team is required to do. Defense attorneys are not required to simply accept all the findings of the police officers, and an investigator may talk to other witnesses, may help illuminate other factors in the case that the police department in the investigating the crime did not look at, or might also help aid in finding witnesses that might provide information that could be life-saving information in terms of mitigation.
And this might be a good place to get into some of the cost of this. Just broadly first, can you kind of give your thoughts on the cost of defending capital cases as far as who pays for it and how much it is? Because I think that'd be pretty surprising to most people.
Yeah, I mean, certainly I don't have figures on the exact tabs and that, the exact bill, so to speak. That would vary per state. But obviously the bill is picked up by the government. No one, with rare exception of, Bill Gates and some athletes, if LeBron James was up for capital murder, he could probably afford his own defense team, but few others could. So the cost of this is always borne by the state, which is one of the reasons why capital punishment is actually a more costly alternative to life in prison, because a simple non-death penalty first-degree murder trial does not impose the burdens on the attorneys to do all this investigation. And as you can imagine, when I talk about all the things that a defense attorney can do, if you're looking at it from a strictly financial perspective, you can just almost see that bill adding up, right? I mean, people flying, it requires flights across the country to talk to teachers, to talk to parents, to look at hometowns, all this stuff. So it is quite costly without being able to give you figures, but it's much more than your regular first-degree murder case, if that answers your question.
Yeah. And I think people would be surprised, right? Because everybody knows that prison and jail is expensive, but I think most people don't think about the cost, not only paying the lawyers, but paying everybody else involved in the case.
Well, there's that, and you think about it, and under a death penalty case, there is automatic appeal to the United States Supreme Court. Now, a lot of people say you shouldn't have that, et cetera, but that's what the U.S. Supreme Court says the law of the land is. And so there are several rounds of appeals associated with a death penalty sentence. Like what I mentioned before, they're going to take a look at what I did, but that just doesn't happen in the sentencing state. Then they go to federal court, they go to circuit courts, they go to the U.S. Supreme Court. It may go back. If anybody's been following the news, there's issues related to execution cocktails. There's issues related to the mental competence of an individual at the time of execution. They could be totally mentally competent at the time of sentencing, but not be mentally competent years later, because one of the things that people don't know when we talk about incarceration costs is that the average time from imposition of a death sentence to execution is about 15 years, to my understanding. Wow. So you're talking about 15 years of incarceration that is also infused, if you will, by numerous appeals. And so not only is that upfront cost more, but the appellate cost is more, because a person who is sentenced to life in prison is only guaranteed one round of appeals on the public dime, and that is simply to state court.
Mm-hmm. Yeah, and I think also, 15 years, there's a difference between 15 years in prison and then there's 15 years in prison on death row, right?
Well, that's the other thing. I mean, you talk about the housing costs of those people, because a lot of people don't realize, if someone is sentenced to death, they are not put in general population.
They're not walking around with people serving time for car theft.
No, they are not, and because the simple fact, that they have nothing to lose, so to speak. If they're sentenced to death, they could be a threat to anyone around. So they are housed by themselves in a cell by themselves. Depending on prison policy, they might be let out an hour or two a day. There's more than likely they have a shower in their cell. And the monitoring is much more extensive as well. So those considerations also rack up the cost for the prisons.
So time-wise, the appeals and everything takes a really long time. What about the case as far as bringing it to trial time-wise? What's the kind of typical or possible timeline from the time the person's arrested or charged?
Well, and I can only really speak to Maricopa County because, but when I started practicing, there was an issue with the state Supreme Court and the rules. I think at that point in time, the rule was, when I first started, or maybe just prior, was that a capital case was supposed to get to trial within 18 months of being charged. But the problem was the burdens were so deep for the attorneys. Not only that, but for the court system, the length of the trials. I mean, an average trial is 3 months. The shortest one I had is 3 months, I should say. Probably the average is a little more like 4 or 5. We can talk about the reasons why moving forward. But so they wound up extending the time to 2 years. And it's not atypical if a conflict arises for that defense attorney, something happens that it could be well past the 2-year mark when a case actually gets to trial.
And I'm assuming, are the people usually held non-bondable, or is it just an insanely high bond?
Well, obviously that's going to vary per state, but in Arizona, if someone's held for capital crime, they're non-bondable.
Okay. So as far as the length of the trials, you said the shortest you've had was a few months?
Shortest I had was 3 months, and that was a cold case, and there wasn't any family involved, and it was just very direct, if you will.
And to give people an idea, a misdemeanor trial might last, a couple hours, and, typical felony trial may last, a couple days or a couple weeks if it's something complicated.
I think, I remember back in the day before I started capital cases bemoaning if I ever had a trial that lasted like 2 weeks.
Yeah.
I was not happy about it. If it lasted over the weekend, I was equally unhappy, that sort of thing.
Right.
But that's, somewhere in the neighborhood of, in Maricopa County, anyway, no more than 8 days. 8 days would be 2 weeks, 8 trial days. But it just, the process of picking a jury and presenting the case, and then obviously if you have a conviction of first-degree murder, the same jury stays in place to judge the sentence, then that takes all that much longer. So you kind of think about the quickest of each of those phases being a month, then you can understand why trials take so long, I guess.
Do most capital cases end up in trial, or do they have to end up in trial? How does that work?
Well, ultimately, the county attorney at the charging jurisdiction is going to have some discretion whether or not they want to offer a plea or not. And, of course, the criminal defendant has a opportunity to decide whether they want to accept that plea or not. A typical plea in a death penalty case is life in prison. So if the risk of death doesn't sound that ominous to a criminal defendant, and given that the alternative is life in prison, sometimes death might be a welcome alternative to that. Pleas probably aren't as commonly accepted as they might be in your standard misdemeanor case, or even a petty felony, if you will. But that being said, I still think, a large majority of those cases do plead out. It's just sometimes it takes a lot of time and investigation for a defense attorney to uncover information about the client that might motivate the county attorney's office to offer a plea. For example, a mental illness, something of that nature.
Mm-hmm. Who makes the determination if they're going to seek the death penalty?
Ultimately the county attorney does. I mean, at least in Maricopa County, and I'm assuming, whether it's a district attorney in another state, it pretty much works that way. It falls with the head of the prosecuting agency. I mean, in Maricopa County, there is I would call it a round table. They call it a committee, but, a committee that decides as well and gives gives input on that rather, but ultimately, it rests with the head of the agency how they want to pursue the case.
And in your experience, are they pretty consistent as far as the type of cases, or, if something's more high profile, or, do politics play into it as far as, what gets charged? What have you seen as far as that?
Sometimes it's hard to think that there's any rhyme or reason to the decision. But, of course, defense attorneys aren't involved in the discussion, so the reasons aren't always apparent to us. But I would say that from the outside looking in, it can appear that there is no rhyme or reason to it.
And that's got to be terrifying if you're the defendant, right?
Well, yeah, I mean, like I say, a typical capital defendant, though, is probably pretty seasoned in the ways of prison and is probably pretty despondent about their life. So, like I say, they may be in the category of just not giving a crap and just being okay with death as well.
Yeah. So when you have a client that's facing the death penalty, because it's something that I'm curious in, because I do a little bit of felony, but more misdemeanor. So, most of my clients are looking at, years or months or, days in jail. What's it like for you, or what was it like initially, knowing that your client was potentially going to get executed?
Well, it's as the lawyer, you have to be as objective about it as possible, and as clear-headed about it as possible. I mean, I found myself making sure that the emotions didn't play into it. I've heard many stories from capital defense attorneys talk about having a growing attachment to the client or a friendship, or because you do, as a capital defense attorney, you get to know them, you get to know their family, that sort of thing. But my approach was always very serious and very legal, and trying to make sure they understood the gravity of the situation from a legal perspective.
And you mentioned the relationship part, and that makes sense because you're spending a ton of time with them, right? Felony case, you might spend, a couple of weeks or months with them. Here you're spending years, right?
Yeah, you're spending, you're spending years with the client. The public defender's office in Maricopa County, I think their policy at the time I was working there is you should see your client once a week. But typically, I'm sure I would see my clients more than once a week. You get to know them, you get to know their families, you get to know their stories. It's, because when you're the kind of law that you're practicing, or that most people practice, is that, you don't really get to know their family members. You don't get to know their backstory. You don't know about their childhood. It might be, did you have a bag of weed? How much did you drink that night?
Right.
Did you hit your girlfriend? It's not, tell me about what life was like growing up. And you get to know them on a different level as well.
Yeah. As far as the defendants themselves, I mean, I'm sure there's a gamut, but as far as their understanding of what they're looking at, you said that a lot have been through the justice system quite a bit. But what have you noticed? I'm sure some are scared, some are less scared. Does it just vary a lot from individual to individual?
It does, and there's because again, when we're talking about a capital defendant, unfortunately, we're not talking about someone who maybe typically has a lot of respect for themselves or their own life. Yeah. But some do. And for some, it's quite shocking, the blow of this idea that they're facing death. And, and it varies over time as well, because, there is when you deal with felons for a while, you come to understand that there is a bravado that is asserted. And sometimes that's something that washes away over time when you get to know them better, and it becomes harder for them to put that face on it. But again, going back to what I said before too, I mean, you cannot debate the logic that if your future is either life in prison or for 30 years, or, life in prison and death in 10, that death in 10 might sound like a better alternative than growing old in prison. So even for those hardened ones, you can see that they in essence have a point.
Yeah. And have you actually heard defendants say that I would rather get executed than, be in prison for the next 30 or 50 years?
Let's put it this way. It's not out of the ordinary.
Oh, wow. Yeah, I guess that would be surprising for most people, but I guess, most people aren't looking at, being inside a cage for the rest of their lives. So I'm sure, if you look at it that way, you can see that perspective a little bit more.
Yeah.
As far as prosecutors, I'm assuming a kind of similar system, that you're going to get more experienced prosecutors prosecuting these cases.
Yeah, definitely. Now unlike the unlike the ABA guidelines that I talked about for defense attorneys, there's no outline of, prosecutors, they must have this or that or the other thing. That is entirely up to the the county attorney's office or district attorney, depending on the jurisdiction and who they want to assign to a particular case.
And you may not know, but any idea what the local guidelines were, or were there any guidelines for, assigning prosecutors or picking prosecutors for capital cases?
Yeah, that would have been something that would have been entirely internal, policy within the county attorney's office, or entirely at their discretion. I really don't know if there's any formalized policy or not. But you're right in saying that it wasn't rookie prosecutors.
Right. In your experience, were the capital prosecutors different at all in their outlook or their approach to cases than non-capital prosecutors? Anything noticeable?
Well,
I'm sure it depends a lot on the individual, but
I think it does, and I guess there's a saying in death penalty litigation that says death is different, and I think that difference brings out a different mentality in everyone that's involved. Everything becomes more serious. And that's probably the best way I can describe it. I mean, regardless of the personality, everything becomes more serious in that courtroom because of the stakes.
And I'm assuming most of these cases, the prosecutors have a pretty strong case, right? Or at least they think they have a strong case.
Well, the typical guidelines, I think, one of the things I heard in law school and even going through criminal defense work is that typically a death penalty case isn't charged as a death penalty case unless guilt is pretty much a foregone conclusion.
Right. And I think that's something kind of different because, I think most people, they watch a lot of, movies or TV shows, where an innocent person is framed or, they're not sure who did it, something like that. In reality, it's probably pretty different, right, with these types of cases.
Well, yes and no. I mean, that is the idea that, without an assurance of guilt, that the death penalty wouldn't be charged. But even here in Arizona, we had a couple death penalty cases recently overturned, death sentences overturned. Ray Crone, who was wrongly convicted off of dubious, shall we say, bite mark evidence, and turns out later DNA acquitted him of the crime. And we also had the case of Deborah Melky, who was accused of killing her son, or at least being involved in making that happen. And we were later to find out that the confession she gave that the detective claimed she gave may not have actually happened because he didn't record it. So what I stated before about guilt being presumed is kind of the general rule, but there are certainly times when those lines get blurred, perhaps.
And I think that's part of the idea of they're having all the extra lines of protection with the appeals and the two lawyers and everything, right? Because the stakes are so high.
Exactly, because it can't be changed. And I wish I could remember his name. There was a gentleman in Texas who was executed for killing his family. The theory was that, and I don't remember what motive was attributed to him, but the theory was that he burned down his home and killed his wife and I believe his two kids. And an arson investigator of sorts came in and gave their theory as to why this was in fact arson. After he was executed and the case was looked at anew, it turned out this arson investigator was wrong. New techniques had been developed and the fire started in an entirely different way. And there's no going back on such a penalty because the man had already been executed. But you're right, that's why those protections are in place for cases like Miss Melky's, Mr. Crone, and presumably preventing tragedies like the one that befell that man in Texas from ever happening again.
Absolutely. So I wanted to ask a little bit about juries in capital cases. Are they well, it's different, right? Because they're there a lot longer being jurors, right?
Well, yeah, I mean, that's the first distinction. You're gonna when you pull a jury in, most people probably think they're gonna come see you, and it's gonna be a 3-hour DUI trial, and they're gonna go home, right? And then instead they go in and they find out, they're being asked to serve on a death penalty case, and they're looking at 3 to 6 months of their lives. And right there, that changes who is eligible or who is able to serve on a jury, because they have to be someone who's able to give up, in essence, that much time of their lives to even be considered to serve on that jury.
And I'm assuming capital cases are like regular cases, and that the judge has a lot of discretion who they allow not to serve when they say that they can't for work or other reasons.
Yes, it's definitely the case that judges. What typically happens, I guess, is that we might bring in a whole, 100, 150, however, whatever the dictates of the case demand, and they're initially screened for time for the judge, and the process is by and large similar to a regular felony case, in that people will say why they cannot give this much of their time to a particular case, and then those whose reasons aren't considered valid by the judge are required to hang on and fill out a jury questionnaire.
Because I'm assuming most people are going to say, right, that I don't want to be here for the next 6 months.
Yeah, I mean, most people are looking to not do that, and you could imagine, though, how many people are, you talk about 6 months of their lives with surgeries and weddings and
kids,
vacations,
work, right,
and different things that they have to do, the hours of the trial, that sort of thing is ominous, because you think about the difference of giving up 3 hours for a misdemeanor trial, or even 3 days for a felony trial, as compared to 3 to 6 months. It's a staggering ask of the courts, and but that is the cost of the death penalty, I guess.
Are the jurors compensated at all?
There are, and I forget the number of days, at least in Arizona, there is what they call a long-term service fund, and the exact numbers involved in that, I can't recall, but there are compensations, but probably inadequate in many ways for a lot of people anyway.
Mm-hmm.
Nobody's getting rich off jury duty.
So when you're picking jurors, I'm sure a lot of it is case specific, but are there any general things that you're looking for?
Well, sure. I mean, if we were to break down all the cases into a couple of sentences, it is that a prospective juror has to be able to consider both a life sentence and a death sentence. Meaning, if a person comes in and says, if they are convicted of first-degree murder, my belief is that they should be executed, then they're gone. My belief is they should absolutely be executed. Doesn't matter.
Right.
If another person comes in and says, my church does not believe in the death penalty, there's no way that I could sentence anyone to death, no matter how many children they killed or whatever horrible thing they did, I could never do that. So they have to be kicked off as well, because they have to be open to imposing both penalties. And that's really what voir dire is designed to do. At least capital-specific voir dire is designed to ensure that a person is open to delivering both sentences.
So you're probably going through quite a bit of potential jurors, right?
Right, and because typically what happens in a capital case is they have a juror questionnaire, and it fills out, and they talk about their views on the death penalty, and it's a different process for people, because there's one of the things that is commonly heard in a death penalty case in jury selection is that the decision takes on a new light when it's real. People might have strong beliefs one way or another about the death penalty when they walk into a courtroom, and it becomes much different when they're looking at the person whose life might be in their hands. And other people have not thought about the death penalty before. And it takes on a whole new light when they realize they could have that power as well.
Makes sense. Just a couple more questions for you. Again, thank you for your time.
You bet.
The one of the main arguments for the death penalty is that, this person did something horrible. They took a life. That's we need to punish them. It needs to be a proportional punishment. So they took a life. We're going to take their life. After defending, so many capital cases, what do you say to that argument?
I say that it's more on a personal level, I guess, than a professional level. I say that life is precious. The person taking the life always feels justified. And, we have to decide if as a society we're going to decide that killing's wrong, then that prohibition should be a blanketed prohibition, whether the killer is a individual that feels justified or a group of individuals in the form of a government that feels justified.
And as far as I know, a lot of countries or industrialized countries don't have the death penalty, right?
That is true. I think the United States, in terms of developed nations, is definitely in the minority. I don't know the exact numbers, but we are definitely in the minority. And the number of states within the United States that have the death penalty on the books, I should say, are diminishing because of the costs and some of the issues involved, the potential for errors that cannot be corrected.
You may not know this, but any idea approximately how many capital cases might be going on in Maricopa County at one time?
You know what? I have no idea. I bet that number fluctuates day by day. I would say that it's probably more than 2 and no greater than 100. But that would just be a wild guess. And because I'm out of the game now, I no longer practice law, so I'm happy to not know those things.
Good. Do you see any trends as far as like the last couple of years or last decade? Are there more capital cases, less capital cases? As far as which way the wind's blowing?
Well, I think we're seeing less because I think in general in this country, because like I said a few moments ago, the number of states with death penalty on their books is going down. So the number of people being charged with the death penalty is in essence going down as well. So I think we're seeing a step away from that as well, because you add on to that the fact that, like I say, roughly 50% of death sentences are being overturned for some sort of error. Then simply put, we wind up doing the same case twice with the hope of executing someone.
Mm. And usually when it's retried, will it be the same defense lawyers or different, or does it vary? I
think it varies a lot because it could literally be years. I mean, I talked earlier about that 15-year time frame. And so, 15 years later, it may not be the same lawyers. They may have retired, moved on, whatever, what have you. So it could be a whole new defense team.
Makes sense. Hey, Mr. Nurmi, thank you so much. This has been a real pleasure. I could come up with more questions, but we're coming up on an hour, so I really appreciate it. Can you please give your website again?
You bet. That is NurmiUnchained.com. That is regarding to my new life coaching practice, is to correct what you said earlier about me practicing law. I'm out of the game. I'm happily out of the game.
Congratulations.
And I'm working with lawyers now to help them deal with stress and things. Once cancer entered my life, a whole new direction emerged, and now I help lawyers who are struggling in their lives. And so if there's any lawyers listening or any other professionals who are stressed out, please check me out on Nurmi Unchained, because there's help available for you. And we could probably do a whole other podcast about health and mental health with lawyers, right? I bet we could. Maybe we will. Maybe you'll invite me back. Hey, Mr. Nurmi. Hey, thank you so much. This has been a real treat. Thank you. You bet. Bye now. Bye.